Welcome back. After 6 years, pro-life pregnancy centers in Illinois finally got their day in court last week over being forced to promote abortions. The case centers on a state law passed back in 2016, forcing Illinois pro-life doctors and pregnancy centers to promote abortion regardless of their moral or ethical conflicts. A federal court issued an injunction halting the law going into effect the following year. The case, called National Institute Family and Life Advocates versus Tetro, comes after the Supreme Court ruled that forcing people to promote abortions is unconstitutional.
And for more on this, we're joined by Kevin Terrio, Senior Counsel with the Alliance Defending Freedom. Kevin, welcome. Good to have you with us tonight. So talk to us about really what's at stake with this law.
This law is really about the government of Illinois attempting to coerce individuals who are medical professionals and pro-life pregnancy centers, compel them to say something that violates their deeply held religious convictions regarding life. They don't want to have to be forced to refer for abortion or to talk about the benefits of abortion, but this law makes them do that.
Kevin, the Supreme Court ruled in 2018 on a similar case in California that said forcing people to promote abortions is unconstitutional. I wonder, is there a different legal question that we're looking at with the Illinois law?
It's really the same question, and that is whether the government can target an individual because of their religious convictions and make them violate those religious convictions. And so we're cautiously optimistic that this court is going to agree with NIFLA versus Becerra and say that that's binding in this instance. And these medical professionals and pro-life pregnancy centers don't have to refer for abortion or talk about its benefits.
So, Kevin, if the California case already settled this, why would Illinois stake a claim or put their foot or dab their toe in the water here?
That's a great question. Their argument is that, well, the medical standard of care already requires this, but that's what the trial was about. And we made it very clear with our experts, and their experts even conceded that no, there's no baseline thing that requires medical professionals who have a conscientious objection to abortion to talk about its benefits or refer people for it. And that would violate the First Amendment to the United States Constitution.
If the court does rule in favor of the pro-life pregnancy centers and doctors, will it send a signal to other states, Kevin?
I think it will. I think there's a really good chance that the court will rule in favor of these pro-life medical professionals, and that will further expand the ruling that the Supreme Court handed down several years ago in NIFLA versus Becerra that we've been talking about.
So you feel really good about where the court might go. Can you talk a little bit about oral arguments before the court? What were some of the questions that the justices were targeting that make you feel pretty confident that you're going to get a solid ruling here?
So this was a trial before the federal court in the Northern District of Illinois, and Judge Johnston asked some great questions about, for instance, when does life begin? And the state's expert conceded that life begins at conception. And the state's expert conceded that when an OBGYN and medical professionals are treating a pregnant woman, they actually have two patients. So they have obligations both to the mom and her unborn child, and forcing them to talk to the mom about killing the unborn child actually really violates their obligations to that unborn child and their ability to make sure that he or she is healthy.
Hey, Kevin, when are you expecting a ruling on this case?
We're in the process of briefing, and that briefing will be done here in the next couple months. And so we're hopeful to get a ruling saying that this law unconstitutionally compels people to say something against their convictions by the early part of next year.
Yeah, that brings up the point. Is this case really more about free speech and compelling speech or religious freedom, or is it both?
It's a great question. It's actually about both. And the Supreme Court has held on multiple occasions, NIFLA versus Becerra, for instance, that we've already talked about, that an individual can't be compelled to say something that violates their deepest convictions. But the free exercise clause of the First Amendment also says that the government can't target you because of your religious beliefs. And that's exactly what this law does.
All right, Kevin Terrio with the Alliance Defending Freedom, thank you so much for being with us tonight.
Thanks, Kevin.
Appreciate you having me on.